Hear ye, hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case this morning is 2019-1560, Robert Wilson et al. Versus Abukar Atiq Durrani, MD et al. You'll notice that in place of Justice Fisher, we have Judge Scott Quinn from the 5th District Court of Appeals, and in place of Justice DeWine, we have Judge Bill Klatt from the 10th District Court of Appeals. Both justices have recused themselves, and these appellate judges are sitting by appointment. Thank you, gentlemen. Welcome. For the appellant, I'm going to ask Mr. Herzog, please, to begin.
Madam Chief Justice and Justices of the Court, good morning. I am Aaron Herzog on behalf of appellants. I'd like to reserve 3 minutes for rebuttal. May it please the Court. When the General Assembly wrote the Medical Claims Statute of Repose, Revised Code Section 2305.113C, it included specific exceptions that could extend the very strict 4-year limit on bringing a medical malpractice claim in Ohio. The reversal saving statute, Revised Code 2305.19, was not among those exceptions. The court below nevertheless found that it could extend the statute of repose. The decision below is contrary to the plain language of the statute of repose, the nature and purpose of statutes of repose, the tools of statutory construction that this court uses, the structure of Ohio's general scheme for limitations on civil actions, and the logic of this court's decision in Antoon. And I think...
Counselor, what's the purpose of the statute of repose? Why was it enacted?
There are several purposes, Your Honor. One is to ensure that medical providers have notice of claims. Another is to ensure that those claims don't get stale. And most importantly, I think it is to end the firmly and finally end claims so that they can be free from liability, is the language that this and other courts have used.
So for those 3 reasons, how does the savings statute go contrary to those reasons?
I think most importantly, Your Honor, the savings statute would allow medical claims against medical providers to continue essentially for many, many years beyond what the General Assembly has.
How many years? If you only get one refiling.
It's unknown, Your Honor. As you know, in Ohio, you can voluntarily dismiss under 41A on the eve of trial, refile. And so a case might have been going on for 7 or 8 years. A plaintiff could dismiss and refile and then start the clock completely over because, as this court has said very clearly in Antoon and many other cases, a dismissal under 41A terminates the original case as if it never happened, and a new case commences at that point.
But the defendants are on notice that there's a claim. I mean, all the reasons for the statute of repose here are not. There's no derogation of those when applying the savings statute that applies to all cases. I don't see how this should be any different.
Two points, I think, Justice Stewart. One is it does not serve all of the purposes of a statute of repose. One of the purposes is to firmly and finally end liability and the specter of liability for medical providers. And the statute of repose, as written by the General Assembly, intends for that period to end 4 years after the act or occurrence. So that certainly is not met by the saving statute.
No, the statute of repose is commencing within 4 years. Commencement.
Yes, Your Honor, and this court has been very clear since at least the DeVille case in 1959 that when a case is dismissed under Rule 41A, it is as if it never existed. And so you look at the new case and when it commenced. We think the logic of Antoon really drives the decision here, Your Honor. And while this court left open the question, it did not suggest that the courts of appeal should write on a blank slate. In fact, there are important lessons to be drawn from Antoon.
Well, from a legal standpoint, yes, it's as if it never existed. But the defendants are put on notice of the claim, which is one of the things the statute of repose is supposed to protect. Because I would imagine if there's litigation on a case and then it is dismissed as if it never happened, I can't imagine a defendant could go to the lawyer and say, well, I don't owe you anything because the litigation never happened.
Your Honor, I'm not going to dispute the fact that that in this situation, that particular purpose of the statute of repose is not really at issue. These cases were refiled fairly closely in time afterwards, so there was notice. Of course, as you pointed out, the question really is one of law, not policy, and so we think the statute of repose is very clear on its plain language. And that, as I was saying, the decision in Antune says very clearly that when looking at the statute of repose for medical claims, the court should look to the newly filed complaint, the complaint in this case filed in Hamilton County in 2015, and decide whether that complaint was filed within 4 years of the act or occurrence. There's no dispute here that it did not. And so we think the statute of repose applies. Fundamentally, the one thing I think this court and the General Assembly have been clear about in Antune, going back to Ruther and other cases, is that statutes of repose are different from statutes of limitations, where statutes of limitations can have equitable tolling or the exceptions generally in the statutes apply. Statutes of repose are to be read strictly. That's not just what this court says, it's what the U.S. Supreme Court has said over and over again, including CTS Corp. Versus Waldberger and the CalPERS cases that we cite in our briefs. So while the underlying policy considerations may be useful, I think this court has to start with the plain language and read the statute of repose as the General Assembly intended it. This is part of a long-running work by the General Assembly in this court to understand the limits of medical malpractice claims. The General Assembly has put very strict limits on those claims. It treats them very differently. A plaintiff has to get an affidavit of merit, which is not something we require of other torts. The statute of limitations is only a year, and there is a statute of repose. We think the General Assembly has signaled very clearly that medical malpractice claims should be strictly limited. And this court
Counsel, the saving statute then has no relevance here. If you say that the statute of repose is the consideration, the guidance here, the savings has no, even though they filed within the 1 year. Is that what you're saying?
Yes, Chief Justice. The saving statute applies to statute of limitations, and it in fact applies to statutes of limitations in medical claims. This court has said so since Saunders in 1984, and we don't dispute that. It applies to statutes of limitations generally. We think the rule is and should be reinforced here that there are no exceptions to extend statutes of repose other than those explicitly written into the statutes by the General Assembly. We think that's what this court's, the logic of this court's Antune decision dictates. We think that's what Ruther dictates. And so yes, the saving statutes applies to the statute of limitations unless the General Assembly expressly says otherwise. And if you see at page 24 of our brief, we have a chart that shows that the General Assembly has from time to time done that. It references 2305.19 in the product liability statute of repose. And so there we think the General Assembly was saying, yes, use the saving statute. The key here too, of course, Your Honors, is that the General Assembly has specific exceptions that it did write into the statute of repose.
Counsel, couldn't the legislature have said this saving statute does not apply to the statute of repose?
Yes, it could, Your Honor, but I don't think it ever thought that it needed to based on the long history of jurisprudence of this court and the state of Ohio.
The ever-changing legislature. You don't think that because time and time again, we have seen where that isn't necessarily the case. So if they wanted to be clear that it didn't apply, it seems like they would specifically have noted that.
Yes, that could have been another way they did it. I think they did it very, very clearly here, though, by incorporating certain exceptions and not incorporating others. I think of it, frankly, as there being a menu of ways to extend statutes of limitations in Ohio law. The saving statute is one of them. Unsound mind, disability, or minority is another. And the General Assembly chose from that menu, picked particular things to put into 2305.113C, crafted a very detailed and specific exceptions to that in Section D of this statute. And so I think you have to read that to say that what they didn't incorporate, they did not intend to apply.
Counsel, plaintiffs use the saving statute for a variety of reasons, and it could amount to, on the eve of trial, having one of their experts pass away or some type of emergency like that. And they might refile the case right after a month, but after the statute of repose. Do you think the legislature intended cases in which that occurs to be not decided on the merits simply because the refiling fell after the expiration of the statute of repose? Something that had been being litigated fully beforehand?
I do, Your Honor, and I think that this court has made clear that that is permissible. I think when you look at, there are lots of consequences to Rule 41A dismissals. I think Justice McGee Brown in her concurrence in Ruther made clear at paragraph 38 of that decision that any deadline may have a harsh result for the person who misses that deadline, but those are the choices the General Assembly is allowed to make in deciding what.
But after the deadline isn't missed here. That's the point. It's not missed. And an example that Justice Donnelly gave, there is nothing missed. The litigation has gone on. Missing the deadline is one thing, and the statute talks about commencement. Clearly, the action has been commenced.
Justice Stewart, I think Antune makes clear, though, that once voluntarily dismissed, this court and the General Assembly treat that action as if it was never commenced. So I think you really do have to look at the new filing of the new action. And
how is that? How is your interpretation just? How is it just from a policy standpoint, from a statutory interpretation standpoint, from a case law standpoint of cases should be decided on their merits?
I think, Justice Stewart, that the General Assembly, as this court said in Antune, is balancing, is essentially the one that determines that balance of fairness and justice in this setting. To go back to what Justice McGee Brown said, she said the results may seem harsh, but it is the General Assembly's decision to determine where to draw those lines. This court, if I had filed my memorandum in support of jurisdiction at 5:01 on the day that it was due, would have told me that I couldn't continue my appeal. It is a harsh result, but it is one that this court enforces strictly, even if that might be unjust for my client. And certainly if this court can enforce rules in that strict of a manner, the General Assembly can decide to enforce strict rules as well.
And there are also, this is where this court takes, not on civil matters, obviously, but also grants delayed appeals that are not timely.
It does from time to time, Your Honor, and the General Assembly, if it was making the deadlines for this court, could make those choices as well. But I do think those are the choices for the General Assembly to make. We think they've clearly made them here. Okay. Madam Chief Justice, I'm over my time. I'd like to reserve what I have left for rebuttal.
Okay, thank you. Mr. Flowers.
Good morning, Chief Justice O'Connor, members of the court. My name is Paul Flowers. I represent the plaintiff appellees in this case, Robert Williams and Michael and Amber Sands. I have a number of co-counsel on the case with me who I'm not going to introduce, but I know they're actively watching because of all the text messages I'm receiving. And with that, I will say, I would like to start off with Justice Stewart's initial question, which I really thought got right to the heart of it, and that dealt with the policy considerations. And let me just say first, I thought one of the criticisms of the first district's opinion that is unfair is that they were engaging in public policy, which is not true. They were following legislative policy. There's a big difference. We know what the legislative policy is for the statute proposed in this case because this court identified it in both Antune and in Ruther. And what we're really looking for here is to, one, make sure there's no indefinite litigation, indefinite filing of litigation, and two, to provide certainty and predictability for the defendants. And the first district just looks at this and says, you know what, this doesn't violate any of that. They're using it as a cross-check. They're just applying the plain and ordinary meaning of these two statutes, which can be applied together. And the first district's opinion looks at that and says, by doing this, we are not overriding these policies. The defendants get notice within the 4 years of the lawsuit. They can preserve witnesses. They can gather evidence. They can prepare their defenses. They have the notice. That's what the statute proposed is intended to accomplish.
So instead of looking at policy considerations, I'm most concerned with the actual language of the statute. So how do you address the language that we have in the statute to propose that I'm paraphrasing, but says this is it. This is all you have. It's 4 years. How do you address that?
No, I agree with you 100%. You have 4 years to file your claim. It's the other side of the window. So statute of limitations is one side of the window, statute proposed the other side of the window. You have to file it within the 4 years. And that was accomplished here. I mean, it was done and the statute proposed was satisfied. Statute proposed at that point can be set aside. Now we have the statute of, we have the saving statute that comes in only because the action had to be dismissed to get a venue that was going to lead to a faster trial in Hamilton County.
But counsel, according to my calculations, and maybe my math is off, but didn't the Wilson's 4.5 years post-surgery and Sands 5 years post-surgery in the filing?
For the refiling in Hamilton County?
Yes.
Yeah, so that's about right. The refiling in Hamilton County was 5 days after the dismissal. That's December 16, 2015. And then we had about 2 weeks for the Sands. They refiled on December 9, 2015. You know, scarcely any gap in time at all.
Well, you know, scarcely, you know, I mean, that's not what the statute said, as Justice French. The statute of repose bars a suit that is brought after a specified time. And it, as codified, provides that medical claims must be commenced within 4 years after the occurrence. So clearly, the filing in Hamilton County was after 4 years. There's no dispute on that, right?
True. The filing in Butler County was within 4 years, well within 4 years.
But that's as though it never happened.
Right, the nullity theory, right. And if you go down that path, then all of a sudden we can never apply the statute, the saving statute to any case.
Wait a second. That comports with Antune, does it not?
Well, we have no problem with Antune, at least not today, but we have no problem with Antune today. And everything we're saying and all our positions are entirely consistent with both Ruther and Antune. Yes, there's a lot of Supreme Court cases that remark that once you voluntarily dismiss a case, it's as if it never exists, but that's never been applied to an extreme. So for example, if you have an appeal in the first case, it's remanded, and then the plaintiff voluntarily dismiss that case, we don't rip that appellate decision out of the law books. It's still there. And if a defendant makes an admission, or any party makes an admission in the first case in a deposition, they're stuck with that admission in the second case as well.
What happened with Antune?
Well, with Antune, this court didn't go to the question of whether or not the saving statute applied. I mean, Justice Pfeiffer pointed out that would have been a really quick and easy way to resolve Antune. But that issue wasn't resolved, and for good reason. The case was already resolved in the fact that they didn't meet the statute of repose in the first place.
Well, right. In Antune, it was as though it never happened. The first filings didn't save the subsequent.
Well, there's that sentence in Antune, absolutely, but I don't think that was critical of the decision at all. It wasn't. I mean, Antune was a procedural mess. A lot of it was filed pro se. They just didn't satisfy the saving statute in the first place. I mean, here, both claims were filed within the 4 years. So as Justice Stewart indicated, nothing was missed. Everybody was on notice. They could prepare a defense. All the purpose of the statute were satisfied. And one thing I thought was really interesting going through all this case law was Judge Monk's concurring opinion in the McNeil case in the first district. I mean, Judge Monk looks at section C2 of the statute of repose, and I'm paraphrasing here, but section C2, if an action is not commenced in 4 years, any action upon that claim is barred. And he looks at the interaction between an and any and says, it's contemplating future actions. So the converse is, if an action is filed within 4 years, then any action on that claim is not barred. So it does contemplate future filings and future claims. And that's what Judge Monk said. And remember, he's just one of several Ohio judges now, Ohio appellate judges, who have all gone our way on this. I mean, there is no Ohio appellate level judge who has adopted the defense's interpretation of these statutes, nor is there any federal judge applying Ohio law. They've all gone our way on this as well. And I think that does say a lot, that all these judges can read these statutes harmoniously and say, like, we can satisfy the purpose of this one, we can satisfy the purpose of this one. They work together. There's no need for exceptions and whatnot.
Mr. Flowers, I have a question. It seems to me that when the legislature wants these saving statutes to apply to a statute of repose, it knows how to do that. And it does it expressly by referencing that exception to whatever statute of repose it's considering. And it certainly did that with the products liability statute of repose. So and this obviously is one of your colleagues' arguments, that when it wants the statute, the saving statute to apply to a statute of repose, it knows how to do that, and it expressly does it. And it did it with the products liability. It did not do it with respect to a medical claim. Why doesn't that indicate that it intended for the saving statute not to apply in this case?
Well, that's what Justice Gorsuch in the U.S. Supreme Court referred to recently as the canon of donut holes. This idea that because an exception isn't there, we're going to make an assumption from that, or because specific language doesn't exist, we assume that they meant to exclude that. As the first district recognized, and then they were citing the Antune or the Atwood case, it's a real poor measure of statutory interpretation. So what Justice Gorsuch,
but it's a well recognized one. It has been applied in many cases, at least in this state.
Well, this is Justice Gorsuch's decisions from Bostock versus Georgia, which came out just a couple of months ago. It's the big homosexual transgender Title VII case. And he writes, nor is there any such thing as a canon of donut holes in which Congress's failure to speak directly to a specific case that falls within a more general statutory rule creates a tacit exception. Instead, when Congress chooses not to include an exception to a broad rule, courts apply the broad rule. And that's just basic, straight statutory interpretation, as Justice French was expressing. It's just the words of the statute. We're not going to worry about what could have been in there, what's in something else, what they might have done, what they could have done. I mean, you could play that game both ways, because you could say just as easily, well, saving statutes here was amended pretty substantially in 2009. They didn't carve out an exception for the statute of repose. Ergo, that means they meant to include the statute of repose within the saving statute. I mean, you can play this game both ways endlessly. And that's why it's just a very poor indication of legislative intent, which we don't need because these statutes aren't ambiguous. I mean, the defendants kind of allude to this in their brief. They say, if it's ambiguous, then this, they don't want to come out and say it. but it's easy to read. These words work together. Quite a few Ohio judges have already concluded that both of these statutes can be read harmoniously together and serve their purposes.
So you really don't have an answer to the logic of the point I made. You just don't like the point. That's what it sounds like to me.
Well, no, you know, what I'm trying to say, maybe not too eloquently, is that trying to pick out what the legislature could have done, what they could have excluded, what they could have included, that's a game that everybody can play from both sides. And we can play it just as easily as they can. So I'm urging the court not to go down that road, which the first district refused to go down, and for good reason. Now it's interesting, the Wade case, and this is the 1986 decision from the 10th district that Judge Norris wrote, who's still sitting on the Sixth Circuit today. The defendants have completely misinterpreted this because he says, you know, there's an exception in the statute, saving statute. It doesn't apply here. Ergo, the saving statute applies to this medical malpractice claim where we've got a statute of repose issue. You know, that's simple. And then he does get into a little bit of this kind of negativity reasoning after that, which he does get criticized for in other courts. But that's way back in 1986 that they looked at this and said, you know, we're just not going to speculate as to what could be there or what couldn't be there. Because all we really know from the legislature is what they intended to do, which was make sure that we don't have, one, endless opportunities to file, and two, we provide certainty and predictability for the defendants. We do know that.
Counsel, they picked 4 years. They, for whatever reason, they picked 4 years in order to achieve that certainty, give a window large enough to accommodate some of the vagaries that happened during litigation. And they say after 4 years, reading the statute, no exceptions, the window's shut.
Well, right. And it's 4 years to do what? And the answer is 4 years to file a claim.
Exactly.
And that was done here. Right. It's not 4 years to get your lawsuit concluded.
Counsel, your claim was as though it was never filed in Butler County.
Right. You know, as I indicated, if that's going to be the holding, then you're going to have to overrule Freisinger. I mean, a case that was unanimous on that point and has stood for 33 years without any legislative interference. Freisinger says...
Counsel, they said 4 years to prevent claims from coming out of the blue, right?
Exactly. It's to prevent that sort of surprise where all of a sudden you've got endless periods to file. It's hard for the defendants to find witnesses and gather evidence after a lot of passage of time. None of that's a concern here because the initial side of the window was met. I mean, those claims were filed in there. Everybody knew it was coming. And Dr. Durrani's choice was to flee. Now, that brings up another point, which is that anything that happens here today is going to be advisory because he fled. Right now, the statute of limitations and the statute of repose is being told. And the tolling statute is very specific as to what it encompasses and includes the statute of repose.
But we don't have that issue in front of us, correct?
Well, you know, I always think it's important for the court to keep in mind when advisory decisions are being rendered. I mean, just the decision rendered in ARMCO versus Public Utility Commission 1982, this court said, it is well settled that this court does not indulge itself in advisory opinions. And that's what we're going to have here because we go right back down and he's still overseas and the statute of repose is still going to be told. So yes, we're talking about important legislative policies or whatnot, but they just aren't implicated here. First of all, because they were met. And second of all, because we're going to have these deadlines extended perpetually just because he's overseas. Even though there are other defendants? Well, the other defendants are a different issue. As Dr. Durrani, you know, he's the main one. You know, he's the main tortfeasor. The rest are corporations and derivative liability. But, you know, with that said, you don't want to give up on anything. I still think it's important, as several Ohio judges have now indicated, and 2 federal judges have indicated, that, you know, you can read these statutes together. And when you do, there's no need for any exceptions to one or the other. They work together just on their plain language. So with that, we would ask you to affirm the First District Court of Appeals in all respects. Thank you.
Thank you, Mr. Flowers. Mr. Herzig?
Thank you, Chief Justice. Several responses. First of all, I think my colleague makes clear that the only way for this court to rule in their favor is to overrule Antune. If you meant what you said in Antune paragraph 24, that an action is as if it never commenced, if the action is dismissed, it is as if it never commenced, then the inexorable logical conclusion is that you have to measure the Hamilton County filing, the new action, not a refiling, a new action, against the statute of repose, and they are outside of it. Number two, the canon of donut holes that Mr. Flowers referenced doesn't apply here. As Judge Klatt was pointing out, here what you have is the General Assembly incorporating specific exceptions, writing in Section D a very detailed exception, and then in another statute showing how it can, in fact, pull in and refer directly to the saving statute where it wants to. So this is not a case where we're suggesting that one exception here means no exceptions elsewhere. We're just demonstrating that the General Assembly knew how to select from the menu of options to extend statutes and decided which ones to apply to the medical malpractice statute of repose and which ones to apply the saving statute. Finally, I'll say that this opinion is not advisory. There may be more work for the courts below to do after this court's decision, but a decision here affects hundreds of cases that were dismissed and refiled for strategic purposes in this case in an effort to create mass trials that this court already had to reject. I see that I'm out of my time, Your Honor. I will simply ask the court to reverse the decision of the First District consistent with its decision in Antune. Thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
All right, our next, do we have counsel? There we go. All right, great. Our next case is 2019-1325, In Re RB, for the appellant cross appellate Paula Adams.
Good morning, Chief Justice O'Connor, Justices, Counsel. May it please the court, I would like to reserve 6 minutes for rebuttal, please, since this is a cross appeal. Thank you. This case involves the First District Court of Appeals misapplication of this court's decision in Jean-Baptiste. It also involves the First District's failure to give any consideration to the General Assembly's specific expansion of juvenile court jurisdiction in these matters, as well as the extension of the length of the court's juvenile court's jurisdiction when it comes to the classification and the modification and the review or the termination, if we will, of a juvenile's sex offender classification. So I think certainly the amicus in this matter addressed the possibility of this court being able to reconsider or revisit Jean-Baptiste, but it's certainly the state of Ohio's position it's not entirely necessary for that to occur, because Jean-Baptiste is very distinguishable from what occurred here, in that the initial classification hearing under 2152.83 is what was involved in Jean-Baptiste. And that is the statutory mechanism that the state is indicating provides the extension of jurisdiction when it comes to RB's case. The statute's very specific that once the initial classification occurs, that continues until and unless it is modified or terminated. So certainly I think that if this court were to want to reconsider, because again, in Jean-Baptiste, that some of those extensions and expansion provisions, those weren't at all addressed in Jean-Baptiste, but again, I don't think it's entirely necessary that occur here.
Counsel, the initial classification happened when the case was being resolved in juvenile court, correct?
Yes, Your Honor.
And he was then a tier 1 reporter, correct?
Correct. And
okay. And so then, pardon
me? There was actually an agreement that was the appropriate level.
Right. I understand how that was resolved. And then he goes through several years and there's counseling and there's, non-reporting probation and a variety of things that happen. And you say that it would be unnecessary for the trial court then to have another hearing prior to the, the end of the case, prior to him turning 21, for the further duties, for another declaration of what his duties and responsibilities are for reporting?
No, Your Honor, I don't think it's unnecessary.
Is it mandatory?
It is mandatory that the hearing take place, but the timing of that hearing, and especially when you look at the circumstances in this case, the timing of the hearing is directory. And I think that if we look at, that's been...
Well, let me stop you right there and see if we agree on this, that there was an initial determination and that followed him for the next 3-4 years, right?
Yes.
Okay. And then it was incumbent upon the court to have another determination made to define his duties and responsibilities with regard to reporting going forward.
Yes.
Okay. And when did that second hearing take place?
Okay. Well, what we have here is an attempt for that second hearing to take place around 2014. And initially, RB had filed a sealing application with the court in 2014. And the court said, you know what, at this time, you're not eligible because we still have to have this completion of disposition hearing. So from that moment forward, subsequent to that sealing, that was denied because they still needed to proceed on whether the classification was going to be maintained. From that moment forward, it was RB who constantly, once that completion of disposition hearing got scheduled, it was RB himself who had constantly been challenging the court's jurisdiction or asking for continuance.
Well, what difference does that make? The court's in control of its schedule.
Correct, but the court, I think, in all regard, understanding that RB wanted to get this matter continued to ultimately have the classification removed, attempted to hold that hearing, that mandatory hearing that the court knew it needed to have. It wasn't that the court was trying not to have the hearing. The court was very patiently attempting to complete this.
Okay, and again, you would agree the court is the arbiter on when a hearing will take place and could have scheduled a hearing within the time before he turned 21.
And it did. It scheduled that hearing multiple times.
No, could have held it. Let's just say he could have held it.
Correct, but when we talk about fundamental fairness here, when he's asking for new evaluations or new counsels coming in at various times of this, I think that we would have a fairness problem if the court at that moment had forced that hearing to occur when they weren't ready for it. I mean, the RB and his side weren't ready for it. So I don't think that the way the court handled this matter was in any way unfair at all. I think that, again, there's been so many arguments in this matter with regard to jurisdiction. And I think when the court looks at the voluminous record in this case, that jurisdiction was constantly being attacked. And so the court was stopping at each moment to address those attacks. And if we look at this, historically, this court's analysis when it comes to whether or not the timing provision that's provided in statute is mandatory versus directory. I think the big indicator here is that loss of jurisdiction is never specifically addressed. If the court doesn't
isn't that really the issue? Not whether it's mandatory or directory, but what the remedy for it can be mandatory, but the question is what the remedy is for the trial court's failure to hold it when it's required to do so. Does that?
I agree with that.
I mean, why is that why would that be jurisdictional? I mean, why wouldn't the remedy be, as in many cases, the court doesn't do something they're supposed to do, you file a writ of mandamus?
Right, and certainly in this scenario, I don't believe that lack of jurisdiction is the appropriate remedy. That the fact that this certainly it's subsumed within this whole statutory provision that this is going to continue on beyond the juvenile obtaining the age of 21. That's, from the get-go, that jurisdiction is expanded. And in fact, I think if we look to the fact that the General Assembly even addressed the general relinquishment of control of a child when they're committed to DYS, when they amended this statute, all other times that when a juvenile is committed to DYS, the juvenile court relinquishes control. But there is a specific exception that's provided in this whole statutory scheme. And I think that speaks volumes to the intent of the General Assembly is not for the juvenile court to lose jurisdiction to make these modifications or terminations of the juvenile, even if they turn 21. And I'd like to reserve the rest of my time unless there's any further questions.
Okay, before Ms. Nestler starts, I neglected to introduce Judge Eileen Gallagher from the 8th District Court of Appeals, who's sitting in place of Justice Fisher, who's recused on this matter. Welcome, Judge. All right, Ms. Nestler.
Thank you. Chief Justice O'Connor, Associate Justices, may it please the court. My name is Julie Kars-Nestler, and I represent the appellee and cross appellant RB. I'd like to reserve 2 minutes for rebuttal. The state this morning has asserted that really this case is about whether a juvenile classification can continue beyond the age of 21. That's not the issue in this case. This court has already decided that issue in DS. This case is about the act of classifying. The act of classification has to occur at a time in which the juvenile court has jurisdiction and the authority to act. The court has authority to act when the statute is followed.
Wasn't a classification already made here?
Your Honor, it was an initial classification. Under the legislature enacted a statutory scheme for imposing classifications. The 0.83 initial classification alone is not enough.
Well, the scheme uses words like can choose to continue, modify. So it seems like it's already been classified here.
Your Honor, I would respectfully disagree with that characterization. The language of the statute specifically makes clear that that initial classification does not continue without an affirmative act by the juvenile court. That affirmative act is the hearing and the classification order under 0.84. And specifically under 0.84.
Where does the statute say that?
Sure, Your Honor. It says specifically in subsection A, it says that the judge shall conduct a hearing to determine if the classification should be continued.
Right, but where does it say the part about it doesn't continue?
I think that's how, Your Honor, it has to be read into that. But
okay.
This is
so it doesn't say that, but that's what you read that to me.
Well, yes, Your Honor, because it's a statutory scheme. Each piece is an important puzzle to the classification. The classification is a two-step process. If the legislature would have intended for the 0.83 initial classification to then enough, then they would not have included 0.84 in this statutory scheme, but they did, so it has to have meaning. These two provisions have to be read together. They work in tandem. Further, the state has relied upon subsection E to argue that they have a continuation of jurisdiction. That reliance is misplaced. If you review that subsection only indicates that the order that will continue, not that the act of classification and the act of jurisdiction to classify is what continues. And moreover, again, it says that the 8.3 hearing is, quote, subject to 0.84. Once again, it's not a complete process without that 0.84 hearing.
If we consider, as Ms. Adams was describing, the attempts by RB to continue the hearing, it isn't part of the problem here that we had those kinds of continuance requests happening. So what should the judge have done in this situation then?
Sure, Your Honor, as an initial matter, first is the mandatory duty on the part of the court. They're in control of this. Secondly, the state mischaracterized the record in this case. The juvenile court did indeed docket RB's case for a completion of disposition hearing in 2014. However, he did not assert that hearing did not happen at that time. Rather, in 2015, April 2015 to be exact, the juvenile court, quote, withdrew the issue of reclassification. That was on the juvenile court. Then we went on from 2015, 2016. It was not until the state filed the motion to hold a completion of disposition hearing that the issue of a completion disposition hearing became at issue again. And it was at that time that RB, that he challenged the court's jurisdiction. I think also, Your Honor, to answer your question, is that importantly, this statute, the legislature was clear and intentional in choosing disposition to be the triggering event for these hearings. The court is in control of that disposition. The disposition is the tether from the court to the juvenile.
What does that mean when you say at the completion of disposition? What is the timing?
That day, Your Honor.
So it has to be that day.
It's that would be RB's position, Your Honor, that provides.
So if the disposition ends on his 21st birthday, I suppose disposition isn't completed until 11:59 of the day before. Or so when's the court hold the hearing? Or your court can't hold a hearing in that case.
Correct. So, Your Honor, again, the juvenile court controls when the disposition terminates. So they can terminate the disposition on the same day and hold the hearing that same day as well. And
they can do it earlier too, though. I mean, the end date is his 21st birthday. They could do it when he's 20 and a half. They could do it at any point they want to reevaluate or, take into consideration, they conduct a hearing of the effectiveness of the disposition and any treatment provided to the child, determination of risk, and all the other factors that the judge has to take into consideration at a dispositional hearing. Does not have to be done on its 21st birthday.
Absolutely not, Your Honor. You're absolutely correct. Again,
but it does have to be done, and you're reading on the exact day that the disposition ends?
Yes, Your Honor.
So the disposition's set to end on a Sunday. The court has to come in, hold the disposition that day?
Again, Your Honor, the juvenile court is the one that controls the disposition. So
what if the child's sick on the day that the disposition's set to end?
Again,
if they're in the hospital?
Again, Your Honor, that is within the providence of the juvenile court.
It's not within the province of the juvenile court if the juvenile goes to the hospital the day that the disposition is supposed to end.
But, Your Honor, the disposition ends when the juvenile court says it ends. So they can extend that disposition out and therefore extend the court's jurisdiction. Again, I wanted to relate back to the...
Counsel, are you saying they can extend it past 21?
No, Your Honor.
Okay,
21
clear on that.
As found, I'm sorry, Your Honor. I didn't hear your question.
I said be clear on that. You said they can just, extend it. That's not, you've got to qualify that.
Okay, Your Honor. So the age 21 is the outermost bound. This is similar to what this court recently found in Ray AW. Age 21 is the absolute last time that is the time the court loses jurisdiction. So the day before is the absolute last time that the court could complete the act of classifying. So for So I know that age 21 plays a role because of the facts of this particular case, but for most youth, it is going to be earlier than that. It could be 15, 16, 17. It all depends on what the disposition was ordered for that youth. And the point that I was trying to make, Justice DeWine, is that the juvenile court is the one that terminates that disposition.
Well, let's say I understand that, but I mean, it seems a little impractical to say, okay, you've been ordered to complete this program. The program ends on a certain day. I set this order for disposition in a certain day. And if the court is not available to conduct a hearing on that very day, then under your theory, there's no jurisdiction over the juvenile.
No, Your Honor, that's not our theory. Again,
well, that's what you said. It has to be done on the day of the completion of disposition.
Correct, Your Honor. But what you're saying is that treatment was the end of the disposition. But for a situation like what the hypothetical you are posing, typically that would require a child to be under orders of probation. And so
okay, so I'm a judge. I put him on juvenile on community control for 2 years. It ends on January 3rd, 2020. I either have to hold the hearing that day, which technically isn't even the completion of disposition under your theory. It would have to be, I guess under your theory, it'd have to be the exact instant the disposition ends, or the court forever loses the ability to hold that hearing. It can't hold it before, and it can't hold it after.
Correct, Your Honor.
And where does the statute say that?
Your Honor, we're talking about the juvenile courts, which are courts of limited jurisdiction.
Well, I understand that, but where does the statute say that it has to be done the exact instant the disposition ends? I mean, we use upon the completion of all the time, and typically we don't say that has to be that day.
Well, Your Honor, this court in interpreting the juvenile sex offender statutes, in NRA-IA and NRA-DS, and John Baptiste, the issue was always, does the court have statutory authority to do the act? In IA, it was to do the initial classification under 0.83B. In DS, it was, when can you determine the age jurisdiction? The jurisdiction is tied to the statutory authority, and you have to follow the statute to be vested with jurisdiction. That's specifically what this court found in Jean Baptiste. The age 21 is the outermost bound to that jurisdiction. If you don't hold the hearing and don't continue the process for classification before the age of 21, that classification is rendered invalid. It's just like in AW, it's just like in Jean Baptiste, and that's why this court should affirm the first district's decision. That's one of the bases. There's an additional basis for RB, and that is that he completed his disposition in 2013, and his hearing should have happened at that time. His disposition was entered December 2nd, 2011. He was placed on probation in order to complete treatment at Altercrest. He completed that residential treatment on February 6, 2013. He remained on probation supervision and aftercare until the juvenile court. They are the ones who took the action. They are the ones who found that they terminated his probation. That is the moment, the July 29, 2013 is the moment he completed his disposition and the moment that the juvenile court had jurisdiction under 0.84 to have the end of disposition hearing. They did not do that, therefore they lacked jurisdiction to continue. Again, the legislature was quite clear that this is a full process or a full scheme. Each piece has to be complied with in order to enter a valid classification. The fatal error in this case is the juvenile court failed to continue RB's classification as required by 8.4 at a time in which it had jurisdiction. Again, RB turned 21 on July 20th, 2017. The juvenile court did not continue that classification until 3 months later on October 30th, 2017, clearly outside the bounds of their jurisdiction. The classification has to be rendered void. Additionally, as I said, the salient issue here for all juveniles in Ohio is when must this completion of disposition hearing occur? And that completion of disposition, that hearing has to occur at the same time. It's practical. I know it's practical. The court knows where the kid is at that time. can bring them in, can provide, they have the records to allow them to be a well-informed fact finder. This case provides the clear example of what happens if that hearing is delayed. Here, RB was unable to, he was unable to present evidence related to the people that were intimately involved in his treatment. The entire purpose of this hearing is to review the effectiveness of his treatment. He cannot have a meaningful hearing when the witnesses that were involved in that treatment are unable to be located and or if they are located, are unwilling to testify because it's been 4 years from his treatment. I think that's important to reiterate one more time, Your Honor, is that the treatment that RB received in this case, it was 4 years from the time that the court reviewed him. That is not what the legislature intended. That's not what this court envisioned in In Re DS when it said that these children would get a procedural protection to ensure that these classifications only remain when it's necessary, when the child hasn't been rehabilitated. The system failed with RB in this case. That leads me to RB's cross appeal. Again, in order to have due process and the promise provided by this court in DS, there had to have been a meaningful hearing, and there just simply wasn't. Additionally, it's quite clear that he was prejudiced. Not only was RB, did he lose an opportunity for removal, but in this,
excuse me, you filed a cross appeal in this case, and I was a little concerned that you filed a reply brief, but the reply brief didn't deal with the cross appeal. It was essentially a surreply on the merits. What should we do with that? That's not allowed by the rules. Should we strike that brief? Should we not consider the arguments you raised in there?
No, Your Honor. I think because the due process claim intertwines with the statute.
Well, this wasn't about the due process claim. I mean, you directly addressed what you directly replied to the reply brief. And that's
Your Honor,
beyond the scope of what you're allowed to do in your briefs.
Our cross appeal, there's two arguments. The first argument is that you must comply with the statute. So we are reiterating the same things of why the statute was not complied with. The alternative argument is that if you agree that the statute was complied with, that simply due process was not complied with in this case. So that is why that reply.
I mean, you have to agree that goes well. That the arguments you made go well beyond your cross appeal. I mean, there's statutory arguments that responded.
It absolutely is, Your Honor. And what I'm trying to, and again, it is because part of our constitutional argument is the failure to comply with that statute also violates due process. I wanted to mention again that RB was.
You used your time. You have no time left. Ms. Adams?
Yes, Your Honor. First, I'd like to point out that all of the case law, and I think we can all agree on this, is only involving that initial classification hearing under 2152.83. And that is what distinguishes here. That statute specifically says that the order continues, the court's jurisdiction to reconsider, to modify, to review that initial classification continues beyond the age of 21. So all of the case law is not applicable. This really is a case of first impression when we talk about the review hearing. And very clearly, this is a review hearing. It's not a new classification hearing. The court is not allowed to then go back and say, oh no, you can either go down a tier or not at all. The court couldn't change the tier to a tier 3 at that point. So this is not a new classification hearing. It is clearly a review hearing. And the court, I think that—
Wait a minute, are you saying that the judge is limited as to what the judge will, in that hearing, post-disposition, cannot relieve the minor of the duty to report?
Yes, they can. They can remove the classification, yes.
They can remove the classification. You're saying they can't go from a 1 to a 3.
Right, they can't enhance it.
Okay,
They can remove
all right, so I'd say that whether the classification sticks and you've got a duty for reporting, or the judge can remove it and you are free of the duty, is a pretty important hearing to have.
It is, Your Honor, and that's why it's important for the juvenile court to get it right. They have, and this is goes to the entire purpose of the General Assembly creating these layers. The court, this is an individual who committed some pretty serious sex offenses at the age of 14 years old. So the juvenile court has another 7 years to deal with this individual. So it's certainly, and there were multiple layers here. He had an inpatient treatment program. And I certainly don't think that it would be at all wise for a court to, once they've finished that period of treatment, to then make the consideration of whether or not they need to register later on. What is prudent here is exactly what the court did, is let's phase back each time, as to what his disposition is. He finishes his treatment, then he's on a period of monitoring with the electronic monitoring, then just probation, and then ultimately down to the non-reporting probation with monitored time. Encompassed within each step of this disposition is the fact that he's supposed to register. And he didn't even do that. In 2015, he stopped registering, and then we have an intervening adult prosecution for that failure to register, which is then based upon, and again, that eats up some more time for the juvenile court, because certainly they're not in a position to intervene while an adult prosecution's ongoing. So I think if we look, and this is a voluminous record, again, it spans multiple years, but everything the court did was in all respect very fair to RB. And I think if you look back at that in 2014, I think the trial court very well, or the magistrate, very well may have wanted to consider that application to seal, but couldn't. So let's start the process. That's what the court was at all, every step wanted to go ahead and have that hearing. They didn't have to have it at that moment. They thought, okay, why don't we bring you in? We'll hold that into disposition, or that completion of disposition hearing, start the process. But instead,
excuse me for interrupting. The word that I get concerned about in your proposition of law is the word permanent. Do you really mean permanent?
Well, I think that yes, for the fact that we had the initial classification hearing. In most cases, certainly we're not going to stretch beyond the age of 21 unless it's absolutely necessary. I think that's very apparent from the magistrate very much wanted to hold the hearing before his 21st birthday. That's very clear in the transcripts. So the word permanent, and that came from a dissent that we had from another first district case here, that I think that it makes it clearer to all the juvenile courts as well as the appellate court that it's once you have that initial classification hearing, that they do have the ability to engage in a meaningful review of the classification and make sure they get it right. That certainly that jurisdiction is going to continue on until they can reasonably hold that completion of disposition review hearing. And that's the reason for the word permanent.
Even if it's 10 years out, 15 years out. I mean, I guess there's got to be something smaller than permanent.
And I think encompassed within, obviously, when we're talking about a tier 1 person, that's going to be 10 years. So certainly, maybe permanent for his life, no, but for that duration of what the duty lasts.
That makes sense.
I'm sorry if I misspoke or misworded that.
Yeah, thank you.
Thank you, Your Honors.
Why do you believe that the juvenile court was divested of jurisdiction while there was a pending Common Police Court General Division action on the failure to report? They're lateral. They could run laterally.
I'm sorry, I'm having trouble hearing.
I'm curious as to why you believe that the juvenile court could not handle any matters while the Common Pleas Court General Division had a pending indictment for failure to report.
Well, I don't think that, I don't know of any legal, but I think that while during the pendency of that, for the court to then go and have a hearing that could affect that, I don't know that logistically, I don't know how that would transpire. Legally, whether or not, they could actually go in and they're courts of equal jurisdiction there. So I don't know legally or technically how that is, but I think that, again, it goes to the reasonableness that the juvenile court was operating under in this case and the fairness. So with that, the state would ask that this court reverse the first district's decision in this matter. Thank you.
Thank you. Ms. Nessler, did you reserve time? Did I hear?
I did, Your Honor. I was out of time.
Oh, used all your time. I'll give you 30 seconds.
Thank you, Your Honor. In this case, the .84 hearing is of the utmost importance. It is not only the hearing that decides whether or not the penalty continues, but it decides whether or not that goes into adulthood. And it's all the collateral consequences that come. And therefore, we ask that this court to hold that in order to have jurisdiction to continue the classification, the court must hold the hearing at the time the child completes disposition and before the child attains age 21. We'd also ask this court to affirm the first district's decision. Thank you.
Thank you. We'll take the matter under advisement. You'll be notified of our decision. Marcia, will you call a recess, please?
The court will now take a brief recess.
19-1430, State of Ohio versus Sean Dowdy. For the appellant.
Yes, Your Honor. Chief Justice O'Connor, may it please the court. My name is Frank Zeleznikar. I'm an assistant prosecuting attorney for Cuyahoga County, and I'll be representing the state of Ohio in this matter. I'd like to reserve 5 minutes for rebuttal. Your Honors, a 20-year to life sentence and a sentence of life with parole eligibility after 20 years is the same sentence. Both are indefinite life sentences. Both allow a convicted offender with parole eligibility after 20 years, and both sentences comply with the General Assembly's intent that offenders convicted of aggravated murder and sentenced pursuant to 2929.03A1B serve life sentences with parole eligibility after 20 years. And that's exactly what happened in this case. Mr. Dowdy was convicted of aggravated murder and with a 3-year firearm specification, as well as an offense of kidnapping. He was sentenced to 10 years on the kidnapping charge, and he was sentenced to 20 years to life on the aggravated murder charge with the 3-year firearm specification. Now, he did not appeal from that sentence. Rather, he waited a few years and he filed a motion to vacate his void sentence concerning the aggravated murder charge. The trial court denied that motion, and denied that motion. And on appeal, the 8th District voided his sentence on his aggravated murder charge simply by saying that
why isn't the issue that he didn't file an appeal from his sentence? Why doesn't that just end the matter? You know, recent decision, Hudson, the case.
No, exactly. And I was gonna get to that. After the 8th District's decision in this case, this court revisited its voidable jurisprudence and held that any sentencing issues imposed by from a trial court that has subject matter jurisdiction and personal jurisdiction over the parties, the defendant is required to raise those issues on direct appeal. He didn't raise those issues on direct appeal, and therefore they should be barred by the doctrine of res judicata, since he did not raise this issue on direct appeal. So I believe that they are barred by res judicata based on this court's recent jurisprudence in Hudson and Harper. Now, even if we were to get to the substance of this case, the sentence, there is no error. There is no error to appeal. In Appley's merit brief, Appley concedes that when imposing a sentence, a trial court is not required to make a rote recitation of the actual statute. So long as the statute complies with the General Assembly's intent, the trial court has not substituted its sentence for the sentence of the General Assembly. And in this case, as I discussed above, the intent of the General Assembly in this case was for offenders convicted of aggravated murder to get a life sentence with parole eligibility after 20 years. And that's exactly what we have in this case. So the question before this court regarding the substance is whether or not there is any sort of substantive difference between 20 years to life and life with parole eligibility after 20 years. And there simply isn't. They're the exact same sentence.
Well, counsel, is there such a sentence as 20 years to life?
Not in the statute, no. There's actually no, it's not a verbatim recitation in the ORC. The ORC says life with parole eligibility after 20 years. But 20 years to life is, for all intents and purposes, is the exact same sentence. The trial court was not required to make a verboten recitation of the actual statute. Now, I've been asking, what is the actual practical difference between the two? And there is none. In his merit brief, Appley makes the argument that by imposing a sentence of 20 years to life, the trial court essentially took a definite sentence and converted it into an indefinite sentence. And that's simply not true. All one has to do is look at the definitions in Black's Law Dictionary of what is a definite sentence and what is an indefinite sentence. And Black's Law Dictionary defines a definite sentence as a sentence for a fixed length of time rather than for an unspecified duration. Neither one of these sentences, 20 years to life or life with parole eligibility after 20 years, is for a fixed amount of time. They're both life sentences with parole eligibility after 20 years. They can be reduced by the parole board after he served the minimum 20 years. In fact, both of these sentences are indefinite sentences. Black's Law Dictionary defines indefinite sentence as a maximum prison term that the parole board can reduce through statutory authorization after the inmate has served the minimum time required by law. Therefore, they're both indefinite sentences since they both are sentences of a max of life that can be reduced once the defendant serves 20 years. Now, for years, trial courts have used these phrases interchangeably. When imposing a sentence for aggravated murder, trial courts have said life with parole eligibility after 20 years or 20 years to life. When imposing a sentence for murder, they've said 15 years to life, life with parole eligibility after 15 years. This is pretty commonplace. And in fact, that actually happened in this case. When Sean Dowdy was initially sentenced on his first sentencing, the trial court imposed a sentence of life with parole eligibility after 20 years. His plea was eventually vacated on appeal. And when he was resentenced years later in 2013, that's when we have this sentence. The court imposed 20 years to life. I mean, there's really never been an issue until recently in the 8th District has starting with their case in State versus Kemp and State versus Smith. They've basically said if the court does not essentially follow the statute verbatim, then the sentence is void.
Counsel, has that practice then been adopted in your jurisdiction, where judges are more careful in voicing exactly what the sentence is?
I would like this. I would like to think so, but we still have situations where courts still use them interchangeably. It's only been really since the Smith case that it's really taking on a lot of steam in the trial courts, and now trial courts are really getting inundated with these motions. And I'm sure they're aware of this case, but we're still having situations where they use them interchangeably. You know, so that's an issue. So I would like to think that they've been more cognizant of that. But at the end of the day, like I've been arguing, they're the same sentence, one way or the other. 20 years to life and life with parole eligibility after 20 years is the same thing. And to vacate these sentences, a lot of these sentences being decades old, 15 years, 10 years, 20 years old, they have these inmates be able to vacate their sentences and then have to hold brand new de novo resentencing hearings on the aggravated murder charge. Not only is a waste of judicial resources, because we're bringing in these defendants and vacating their sentences solely so the trial court can impose the exact same sentence, but just word it differently. And not only that, I mean, it reopens old wounds for the victims' families who have to sit through another sentencing hearing, or 20 years down the line, they get a call from a prosecutor informing them that the person who murdered their
counsel, we are a profession where words matter.
Yes. Whether
lawyers, judges, statute drafters, words matter. And what causes me a little concern is that you said that the practice in the 8th District, given the cases that have been decided by the 8th District Court of Appeals, have not been a cautionary tale for the judges in your jurisdiction. They continue to use imprecise sentencing language.
Well, I mean, yes, I mean that's an issue, and we are, like, as prosecutors, when we're in the sentencing hearings, we're doing our best we can to.
Well, are you in the sentencing hearings at all times? Is there a prosecutor present in the sentencing hearings?
Generally, yes, especially for sentences of aggravated murder and murder.
Okay, and then it would be up to, well, it shouldn't be up to, but it is a duty of the prosecutor to make sure the judge is pronouncing the correct sentence, is it not?
Exactly. Yes, I agree, and they should follow pursuant to the 8th District's opinions. So, yeah, that's definitely something that is a responsibility of the prosecutor. And when that falls through the cracks, I mean, we have to deal with it on appeal. And my position is that when that does happen, when a court does sentence someone to 20 years to life, rather than life with parole eligibility after 20 years, it's the same sentence. There's no practical difference between the sentence. As this court held recently in State versus Bunnell concerning consecutive sentences, this court made it clear that talismanic wordings are not really necessary at sentencing, so long as the intent of the legislature is complied with. So long as the intent of the legislator is complied with, the trial court hasn't substituted its own sentence for that of the one provided by the General Assembly. And here, 20 years to life and life with parole eligibility after 20 years is the exact same sentence. There's no indication of the trial court replacing its own sentence with the one provided for by the legislature. If there's any other questions, I would just ask to save the balance of my time for rebuttal.
Thank you. Mr. Martin.
May it please the court, John Martin on behalf of Mr. Dowdy. My friend says there's no difference. 2 words, no difference. I have 2 words in response, and that is to whom. And it's that to whom. The fact is that the question is not whether it makes a difference to anybody other than the General Assembly, because this court, following its traditional jurisprudence, recognizes that it is the General Assembly that defines punishment. And so if I may this morning, I'd like to talk about 3 things. 1, is there a statutory distinction between 20 to life and life with parole eligibility at 20? Second, I would like to talk about whether or not that distinction implicates void versus voidness. And then third, I would like to talk about the practical effects. The statutory distinction. If we look at 292902, it lays out penalties for murder and for aggravated murder. And the General Assembly says ag murder, either death or life imprisonment. Murder, 15 to life imprisonment. And then we move over to 292903, and it talks about the fact that that life imprisonment can come with parole eligibility. But in 292903, and we cite the statute at length at pages 5 and 6 of our brief, and at 292903 C1a little v, you have a situation where we see that first of all, in 4, it says that, and this is dealing with ag murder where there was a death spec and the jury comes back without death. And they say that, subject to the following subsection, quote, life imprisonment with parole eligibility after serving 30 full years of imprisonment. So that's one of the penalties that the General Assembly recognizes. And then in part Roman 5, little v, if you will, it goes on and it talks about the fact that if you have a victim that's less than 13 years of age and you have certain predator specs and the like, that the sentence is not that. It can't be that one. It is an indefinite term consisting of a minimum term of 30 years and a maximum term of life. So here we have, in the exact same subsection of a single statute, the General Assembly using 2 different terms. And when the General Assembly uses 2 different terms, we presume that they have 2 different meanings. The 8th District has done nothing but apply this court's traditional statutory interpretation jurisprudence in looking at that. And I might point out that Kemp and I don't know what this is worth, but if nothing else, anecdotally, Kemp was written by Judge Kenneth Rocco, who had himself been a 6-year member, I believe, or about 6-year member of the General Assembly. So we have a former state representative who's drawing this distinction between, hey, wait a minute, definite, indefinite. Okay, now, is it a definite term if you have life with parole eligibility after 30 years or after 20 years in my client's case? Mr. Zalesnikar does a good job of telling you that in Black's Law Dictionary, that doesn't make a difference. But again, to whom? To the General Assembly. This court must presume it did make a difference because they used the two terms in different places. Now, if it makes a difference to the General Assembly, then the next question that comes up is, well, what about void and voidness? What am I going to do about the fact that this court has decided Harper and Hudson? Here's why Harper and Hudson are distinguishable. Harper and Hudson, which were both PRC cases, both involved cases where the judge had the authority to impose PRC. Did it imperfectly, but nonetheless had the authority to do that. But in this situation, if we recognize that to the General Assembly, life with parole is different than 20 to life, then we're in a situation where it makes it, then the General Assembly has not said the judge can do both, or can impose either. It's been very specific as to which one. And I realize that one of the questions that comes up is, am I just playing games with talismanic phrases? The answer is no. See, this isn't a question of saying you have to use the exact words, but what you cannot do is to substitute one legal term for another legal term, and then turn around and say, well, it doesn't really make a difference, and therefore all Martin's doing is saying talismanic phrases. No, I'm not. I'm saying that when words matter, legal terms that are distinctly used in different places of a statute themselves also matter. Now, if we don't limit Harper and Hudson in the manner that for which I'm advocating, we run into the following problem. Let's say that we take Harper, and Harper does this wonderful job of taking us all the way back to State ex Roche and really developing the whole line of jurisprudence. But in talking about the jurisdiction of the trial court, I think it's important to remember, and this was not an issue in Harper or in Hudson, that the General Assembly, when it confers jurisdiction on a trial court, it gives it two different lines of authority: the authority to try the case and the authority to punish. See, it's this authority to punish that's the problem here for the state of Ohio, because the General Assembly has not ordained the trial court to punish aggravated murder, in this case, with a 20 to life. It is only ordained the trial court to punish with life with a parole eligibility, which in this case happened to have been imposed at 20 years. And so when the General Assembly uses two different terms, and then in its conference of authority to the trial court to go forward and do our work, it does not give them the authority to go beyond those statutory parameters. If that were the case, then we could have the situation where a common pleas court judge who sentences a defendant for the theft of a loaf of bread as a petty offense and gives him 20 years. And we would say, well, that's voidable. And if you didn't catch that in the journal entry, then in fact, it's too bad. You're going to have to do 20 years on the petty offense. And that cannot be. And we know from the line of cases that Harper cites that a writ of habeas corpus doesn't lie traditionally. in that kind of a situation? Well, if a writ of habeas corpus doesn't lie, and if we look at the Constitution and the other writs that are available, mandamus, procedendo, prohibition, quo warranto, none of those fit. So there has to be a way for the state of Ohio to be able to avoid that type of injustice. And it is through the void sentence doctrine used in limited doses. And that limited dose comes in saying, trial judge, could you have done this anyway? If the answer to that question is no, then the sentence is void. Trial judge, could you have done this, but you just did it the wrong way? Voidable. And that's a distinction that allows Harper and Hudson to make great strides for judicial economy without violating 14th Amendment due process. So if I could, let me move then to my third point. And my third point is, does it make a difference? And I talked in my brief at the very end about the idea that it sends a different message to the parole board, the glass half empty, glass half full. But I want to be a little bit more concrete than that this morning, if I may. And no, let me just say right now, I haven't found a place where somebody serving 20 to life is different than life after 20. But here's what I have found. And I cited a supplemental authority. I cited to the court State Ex Rel Davis versus Janus. And that was a writ case that you decided back in April about 20 full versus 20 to life. Okay, 20 full to life or parole after 20 full versus parole after 20.
But those were two different sentences in that case.
Correct.
That's not the equivalent of what we have here.
No, it's not, Your Honor. And I want to make sure that I'm not trying to suggest that. But what I want to point out to the court, I used that case only to provide the factual background to look at one of the pieces of authority that was cited by both parties, and that was OAC 5120-2-10. And 5120-2-10 gets into the issues about good time in those and when it's going to be treated. And in 5120-2-10B, it talks about that 20 to life and 20 full. And then it says, and you know from Janus that that's a question that was a matter of a statutory mandate, that you're supposed to do one in one place, as Your Honor, as Mr. Justice DeWine points out. Those are two distinct sentences. And then but look at what they say at the very end of that. They say, look, we're going to treat any sentence of to aggravated murders, we're going to presume it to be a sentence of life with parole eligibility after 20, unless the journal entry says something different. So we see that the executive branch is saying, look, if it's in the journal entry, we're going to follow that. Whether that was a legal sentence or not, all Janus did was to give perspective to what was being said there. And the point is this: if the executive branch is going to be following what the trial court journalizes, what the trial court says, what happens if down the road, and this has not happened yet, but I can't come back to you in 30 years, the good Lord willing, I could even be able to, and say to you, my client is not getting good time. And since the time that I was here the last time, Your Honors, the OAC has been changed and there's good time in life cases, but there's not good time in cases involving indefinite sentences, or there's a different calculation of good time in one setting versus good time in another. And it made a difference. And so the problem here is this: if the General Assembly is going to use two different terms, then respectfully, we presume they make a difference. And we see that the executive branch in the past has said, or present has said, we're going to look at that journal entry. We're not going to look at the statute. We're going to look at the journal entry. And if the judge said it was indefinite, in this case, they were talking about 20 life from 20 full, but the point being, the OAC has shown that the executive branch will be guided by the journal entry. And if down the road there are changes, if the parole board takes a different attitude and says, you know, when it's 20 to life, that's different than life with parole eligibility after 20. Regardless of which way they have that arrow point. If they say there's a difference in, if the OAC turns around and says, we're going to treat good time differently, and we've got a journal entry that's wrong, then my client does suffer. So at the end of the day, the General Assembly makes the laws. They pick the words. Trial judges shouldn't be turning around and ignoring one term of art, not term of art, legal term, for another legal term. And then we have the fact that the executive branch, rightfully so, looks to a trial court's journal entry when it decides how it will enforce the law. This is not a situation, and this is a situation where all of this happens, where a trial judge acts without that authority that has to be conferred by the General Assembly. In the end, to whom is the distinction? And this court, employing traditional separation of powers, should recognize the primordial role of the General Assembly in making the law. If there are no further questions, I thank the court for its time.
Thank you. Mr. Zellenbekar, you have let's see, how much longer do you have? 4 minutes and 19 seconds left.
Thank you, Your Honor. I'd like to talk about the Janus case because he brings up a good point. In the Janus case, if you look at paragraph 7 through 8 of the Janus case, that was a situation where the trial court, by including the term fool into its term, actually changed the sentence. There was an actual substantive change. The court recognized that by when the term fool is in the sentence, it precludes the defendant from getting things like good time credit or joining programs. So that was an actual substantive difference. What I didn't hear during his argument was how 20 years to life and life with parole eligibility after 20 years are two different sentences. They're just clearly not. They might be phrased differently, but they're the same thing. And if you look at the Ohio Administrative Code, the Ohio Administrative Code recognizes that, like, even though a sentence for murder is 15 years to life and a sentence for aggravated murder is life with parole eligibility after 20 years, when you look at the Ohio Administrative Code under 5120-2-10G, which governs murder sentences, it states a prisoner serving an indefinite term of imprisonment of 15 years to life for the offense of murder becomes eligible for parole consideration after the 15-year minimum sentence. Now, when you look at the Ohio Administrative Code governing aggravated murder, 5120-2-10K, it basically says the same thing. It says a prisoner serving a sentence of imprisonment for an offense of aggravated murder committed on or after July 1st, 1996, becomes eligible for parole after serving X number of years. So the Ohio Administrative Code doesn't make that same distinction the General Assembly did in between murder and aggravated murder sentences. There just isn't any sort of distinction. And what I hadn't heard during Mr. Martin's argument was how this sentence of 20 years to life affected Mr. Dowdy in any substantive way. It's still an indefinite sentence, regardless of whether or not Mr. Martin makes the argument that the General Assembly intended the life with parole eligibility to be a definite sentence. Just on the face of it, it's clearly not a definite sentence, regardless of any way the General Assembly didn't even define it as a definite or indefinite sentence. That's just speculation on Mr. Martin's argument. It's clearly an indefinite sentence pursuant to the standard, well-recognized definition of what an indefinite sentence is. So they're both indefinite sentences. Mr. Dowdy's going to be eligible for parole after serving the minimum term of 20 years, and this clearly complies with the General Assembly's intent that a definite sense of that a offender being convicted of aggravated murder and sentenced pursuant to 2929.03 A1B, he's sentenced to a life term with parole eligibility after 20 years. There's simply no substantive difference between the two sentences. Now, Mr. Martin also brought up the Harper argument, and I think I introduced as supplemental authority a recent case decided in June by the 8th District, I think it's State versus Brooks, where they basically said an issue like this, and it cited Harper and Hudson. And in that case, I believe the defendant was arguing that the court included or didn't include the term full years when imposing a sentence. And the 8th District in that decision, relying on this court's case in Harper, said that this is barred by res judicata, and he could have raised it on direct appeal and he chose not to. So the 8th District has already determined that Harper's not just limited to challenges of post-release control. So I would just ask this honor to recognize that 20 years to life and life with parole eligibility after 20 years are the same sentence. They're both indefinite sentences, and the defendant in both cases will be eligible for parole eligibility after 20 years. So if there's no further questions, I would just ask this court to reverse the judgment and opinion of the 8th District Court of Appeals.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.
Thank you, Your Honor.
All right, our last case this morning is 2019-1815. John Reitzter, receiver on behalf of Certified Steel Stud Association Incorporated versus William Gardner and Edward Schlisch, and Clark Weston Dietrich Building, DBA Clark Dietrich versus Certified Stud Association. For the appellants, we're going to have a time split. I believe, according to my notes, the first attorney to address the court is James Helmer.
Yes, Your Honor.
Okay, proceed.
May it please the court, Chief Justice O'Connor, Associate Justices and Counsel for the Defense, I am Jim Helmer from Cincinnati, and I represent John Reitzter, the court-appointed receiver in this case. I'm going to split my time with Matt Blickenswerfer, who's counsel for Clark Dietrich. He'll take 5 minutes, and of the remaining 10 minutes, I'd like to reserve 2 for rebuttal. This case presents a straightforward issue to the court concerning the scope of this court's litigation privilege. Does that privilege shield corporate fiduciary directors from suit by their own corporation when they breach their fiduciary duties to their corporation? It's a receiver's position that such an expansion of the privilege by this court would be wrong for 3 reasons. First, expanding the privilege beyond defamation is inconsistent with this court's prior rulings and contrary to the purposes behind the rule. Second, such expansion disrupts long-standing established corporate fiduciary duties with which directors must always comply. And third, such expansion is unnecessary because the statutory business judgment rule in both Delaware and Ohio already protects directors. First, in the last 100 years, this court has considered many times whether a litigation privilege should bar a lawsuit. One of the briefs in this case says that that's happened on 4 occasions. I actually counted 7 such cases by this court, and every single one of them involved defamation. The receiver does not bring a defamation case. So what is this privilege? This court's determined on several occasions that statements made in the course of a judicial proceeding are absolutely privileged against a civil suit so long as the statement is relevant and material to the original proceeding to aid the court in its search for the truth. Now, the Court of Appeals in this case relied upon language in this court's Srirachi opinion, quote, reasonably related to the litigation, unquote, as a basis to expand this privilege. But reasonably related to the litigation is a term of art which has been defined by this court many times. Justice O'Connor, as you say, words matter, and they matter here. Reasonably related to the litigation does not mean anything having to do with the lawsuit is protected by the privilege. The phrase means that to trigger the privilege, the statement or conduct must be essential to proving or disproving the point to be established in the underlying lawsuit, so as to aid the court in the search for the truth. If it is not essential or germane to proving the point, it is not privileged. Here, the search for the truth in the underlying lawsuit concerned whether Certified Steel had commercially disparaged Clark Dietrich steel products. Deciding whether to settle a lawsuit has nothing to do with aiding the court to determine if Clark's products have been commercially disparaged. Settlement discussions do not prove or disprove whether commercial disparagement has occurred. So we have no defamation follow-on lawsuit in this case. The settlement decision, which is at issue, had nothing to do with seeking the truth of the underlying disparagement lawsuit. This case in that regard is very similar to another case decided by this court, Willitzer versus McLeod. Dr. McLeod was an expert witness doing out-of-court medical exams to prepare his testimony for presenting to an industrial commission. Court found no privilege protection for that. Like Willitzer, here the directors were sued not for any testimony. Instead, it was for their out-of-court conduct committed at a board meeting in breach of their corporate fiduciary duties. Had nothing to do with the search for the truth of whether commercial disparagement had occurred. Directors' breach of their fiduciary duties at a board meeting simply does not aid the court in the truth-seeking function for the underlying lawsuit. It's not.
Counsel, I recognize that that certainly is one of the purposes, is to get at the truth. But what about the other issue that your friends on the other side raised, which is to prevent a flood of follow-on litigation, to give a definite end, that you shouldn't see additional liability based on something that you did in one case? How do you respond?
Your Honor, that is a red herring in my view, because there is no flood of litigation for these issues.
Well, would you agree, though, that that is one of the purposes for the litigation privilege, for the litigation immunity?
I would not agree that's a purpose at all. I would agree that that is a benefit that has been acknowledged by this court and other courts around the country, that it would stop litigation. But for the reasons that I'm about to get into, this litigation should not be stopped.
Well, but isn't that a different question? I mean, what we're thinking about is really how are we going to apply this looking prospectively in every case, rather than how are we going to apply it in this particular case?
Well, first point, Your Honor, was it should be applied in defamation cases only. But if you're going to expand it beyond defamation cases, then you should use the test that this court's already enunciated, which is it has to be reasonably related to the litigation. And if it's not, then the privilege could apply and there wouldn't be any flood of litigation.
How could settlement discussions not be reasonably related to the litigation?
because as that term is defined, it has to either prove or disprove the underlying issue in the lawsuit. Settlement discussions, nobody admits anything in settlement discussions. They don't prove or disprove anything. So if you apply this court's definition, then they would not be covered by the privilege.
Thank you.
Secondly, Your Honor, the directors are fiduciaries as a matter of law to certified steel. The receiver pled that their fiduciary duties were breached, and this court must assume that. Fiduciary duties aren't like a light switch that get turned on and off. They are unremitting and constant. They do not cease at the courthouse door. And finally, Your Honor, and my time's about to run out, providing absolute immunity here is unnecessary because both Delaware and Ohio recognize the business judgment rule. That protects decisions by directors, assumes they're made in good faith, but it's a rebuttable presumption. And in egregious cases like this one, that presumption can be rebutted. The appeals court decision here not only nullifies corporate fiduciary duties for directors, it also eradicates the business judgment rule. I would defer to Mr. Blickensurfer at this time.
Counsel?
Chief Justice O'Connor, and may it please the court. Chief Justice O'Connor, and may it please the court, I'm Matt Blickensurfer on behalf of Clark Western Dietrich Building Systems, LLC, known as Clark Dietrich. I'd like to take 5 minutes of the remaining time without reserving any of that for rebuttal. Justice French, I'd like to start with your question to Mr. Helmer about the benefits of follow-on litigation. And I think one of the responses to that question is, as Mr. Helmer said, that may be a benefit of the litigation privilege, but it is not a good way to define the scope of the litigation privilege. And that is because there are other doctrines that address and solve the problem of follow-on litigation within the given context of a particular tort. In this context of our case, that problem is addressed by the business judgment rule. The presumption against second-guessing director decisions discourages follow-on litigation and acts to eliminate a lot of such litigation at a very early stage when it has not been discouraged in the first place. Other tort theories, such as professional negligence that might come in this context, also have elements to them that are going to make follow-on claims hard in the first instance. And so, yes, it's a reasonable policy consideration to think about follow-on litigation and finality of litigation, but we already have other doctrines that address that problem. And in grafting that goal onto the litigation privilege creates problems. It creates problems because the litigation privilege is an absolute immunity that prevents even the inquiry into the underlying conduct. And that fundamentally is the problem with the 12th District's rule here, Your Honor, and also with the position being advocated by the defense. Their rule would preclude even inquiring into a breach of fiduciary duty in the context of litigation. Interpreted literally, as the dissent below indicated, the 12th District's rule would preclude any inquiry, even inquiry into professional negligence claims in the context of litigation. Your Honors, that can't be the law of Ohio. And it's not the law in other jurisdictions either. And other jurisdictions have taken three general approaches to addressing this kind of issue. That is corralling a litigation privilege that sweeps too broad. Some states and the restatement adhere to the traditional rule so that the litigation privilege applies only to defamation claims. Other states have expanded the array of terms which the privilege applies, but they keep them limited to those that sound in defamation. That is, claims alleging a reputational or psychological injury arising out of litigation testimony or evidence. Still, other states have a broader rule that's articulated generally for the privilege, but then carve out exceptions or impose significant limitations on the otherwise broad scope of their general rule. The most common of those exceptions is one for professional negligence claims. And that's based on the common sense idea that the litigation privilege isn't intended to prevent a principal from suing its own agent for negligence or misconduct in the context of litigation. And that exception provides a very nice analogy to this case. Some other states have carved out other exceptions to another rule and have done what the dissenting judge below proposed, which is limiting the claims to which the privilege applies to those that are brought by a party opponent in the underlying litigation. And that kind of exception also addresses the concern that you raised, Justice French. Both of those exceptions that states have carved out to broad general scope definitions of the litigation privilege exhibit a point that's very relevant here. And that is that the litigation privilege should not be used to deny recourse to a litigant who has been wronged by the agent or representative of that litigant. Any of those options that other states have chosen would solve the fundamental problem here of a privilege that sweeps too broadly. We think the one sounding, limiting the scope to those sounding in defamation makes the most sense, Your Honors, for the reasons we've articulated in our brief. I'm at the end of my time, Your Honors, and I will yield the balance for Mr. Helmer's rebuttal.
Thank you. All right, for the appellee, I guess first we're going to have Mr. Pollack.
Yes, Chief Justice. Chief Justice O'Connor, Associate Justices, it's a privilege to appear here for you today. I'd like to address two issues. One, that the litigation privilege does apply, and two, that even if the court were to go to the business judgment rule, that the receiver has failed to state a claim. In this regard, I'm going to narrow myself solely to what the receiver actually pled. Mr. Helmer makes additional arguments today, but I'm going to narrow myself to literally what he pled. Page 2, paragraph 2, page 6, paragraph 16, what he pleads is that the CSSA opposed the motion to dismiss and instead insisted upon having the jury decide the matter. He does that by requesting a vote. So he's responding to Judge Spaeth. And by the way, at that time, Chip and Ed, this is Chip Gardner, my client, Ed Slish, co-appellee, were parties. They were the CSSA. A corporation speaks to its representatives. And at that point, they were responding directly to a judicial inquiry. And they said, we want to have the jury rule. That is absolutely, I've just stated, a prima facie case of the litigation privilege because they're litigants in the course of a case and they're responding to a judicial question. So with regard to Willitzer, which Mr. Helmer grasps onto, Willitzer is an odd case because it deals with a private medical exam being done apparently for a labor dispute. But the court there had a 4-3 split. It was a closely divided Supreme Court of Ohio. And they drew the following line. It was an investigative medical function, not a quasi-judicial function. Asking for the jury to rule is as close as you can conceivably get to the litigation process. Mr. Helmer then argues, well, it's a narrow rule. It really doesn't apply here. But Srirachi tells us it's a liberal rule of immunity. It extends to every communication at every step in the course of litigation, from complaint to the end. Further, pleadings and statements, and this was a pleading, we want to have the jury rule, is protected. Perjury is protected, clearly in derogation of the truth-finding process, but this court has found, as others have too, and that's Schmidt versus Statistics, Stoll versus Kennedy, that perjury is protected, as is bad faith statements. So the narrowing that Mr. Blickensderfer and Mr. Helmer attempt really is not true. The fact is this court has embraced a broad rule all along.
Mr. Paul, let me, excuse me. Let me give you this hypothetical. Suppose the directors of Procter & Gamble decide that all this consumer products making is too much work, and instead they're going to devote all their corporation's resource to patent litigation, sue people who they think are breaching their patents. And a few months later, they announce the decision, their stock price plummets. Would they not be liable? Could they not be sued for breach of fiduciary duty?
Two answers, Your Honor. if you don't let me change your fact pattern just slightly.
No, just why don't you answer this fact pattern? Let's stick to this one.
I like Coca-Cola, which is why I put on weight. But if they tried New Coke, it was a horrible disaster. If they came back to New Coke, or if they go and they decide they want to focus on litigation, there is a great question about whether they've acted appropriately under the business judgment rule, perhaps, if the stock prices plummet.
Right. The question is, and let's go back to my hypothetical. This is, I think, akin to what we have here, which is a decision whether or not to continue or pursue litigation. Would the directors in that example, under your reading of Ohio law, would they be entitled to a litigation privilege? These were decisions about litigation.
Well, I don't know whether they'd be entitled to litigation because it's not made in the courtroom directly related to litigation. It is somewhat related as a business decision, business discussion. If we look at the business judgment rule, which will be
okay. Well, I think we need to talk about the privilege, though. That's kind of the issue we accepted. What you say the difference is that they were in the courtroom and that. What imagine, for example, the directors in the courtroom, they get a very reasonable settlement offer, and the directors decide that they've hired their brother, one of the directors' brother-in-law, to continue the litigation. He's making a lot of money. They don't want to accept the settlement offer because they want him to continue to get paid in this case. Is there a breach of fiduciary duty claim?
There may well be, but
what's the difference under your version of the privilege? If it immunizes these decisions, whether to accept settlement offers to go forward with litigation, why wouldn't it apply?
Because in the case where a corporate board is ill-informed and makes a bad decision because it's just not informed, or makes a decision out of bias, and it's not making it in the courtroom, it's making it in the boardroom, if you will, it's making a business decision, there may well be a breach of fiduciary duty. But
so it depends on the locale the board's sitting when they make the decision?
No, Your Honor, respectfully, they were at 6 weeks and into a jury trial. They're sitting there on Sunday night, they get approached at 9 p.m., and they have to make a decision as a board, what do we do? They then actually accept the offer the following day. So exactly what the receiver complains about, they then did. That is a little different than coming up with the idea of selling poison as a board and deciding, we're going to bypass the FDA rules.
Right, but you're asking us to adopt a rule that would apply to all those situations. I mean,
I'm not. Respectfully, Your Honor, I'm not.
Well, give me the contours of the privilege that you would like us to adopt.
I think we stick square within litigation privilege. In this case, it was a statement in response to a court in the courtroom because their lawyer was there in the courtroom. They were negotiating in the courtroom. They responded Monday morning to the court. That is very different than some, if you will, contrived corporate conspiracy where the corporation's acting in its own self-interest or bias, if you will. And
okay, so should we have a privilege, but not the reasonably related privilege to the litigation that the lower court had?
I think it has to be reasonably related. Saying I want to have the jury rule is as reasonably related as statement as you can get.
Okay, but I'm just trying to understand what your standard would be, because if we're going to have to make a decision, if we're going to have a standard, we have to articulate it. So,
right, Your Honor, my respectful suggestion would have been, and I know it's up to this court, is that the wheels of justice turn slow but mighty fine. Mr. Blickensderfer throws out, and they've thrown out the idea of lawyers assaulting judges and people assaulting witnesses. I can't deal with that fact pattern because right now I'm not asking for a grand rule. I think the dissent got it wrong here.
But do you think the majority got it wrong because the majority articulated a grand rule that would cover those situations?
I think the majority got it right because they were applying it to this fact pattern. I don't think they were trying to resolve just a rule that applies to every case everywhere. The fact pattern they were posed with was on the eve of trial, litigants decide that they want to have the jury rule. That's the fact pattern they got. They weren't asked about these other cases. And so to me, perhaps it comes with a different scenario if a corporation acts in its own self-interest. But the fact is that's a little different than the fact pattern we've got. And I think the facts make a difference. Does that answer your question, Your Honor?
Not really, but I think you're...
I apologize, Justice. I'm not trying to avoid your question. With regard to the majority rule, this court has followed the majority rule in the restatement ever since 1930, restatement 1, 2, and 3. This case falls squarely within the restatement of torts. The purpose here, of course, is to make sure that every witness can testify. If we accept the rule that they're articulating here, then the witnesses would not be able to testify because everyone will be terrified if they walk into Ohio, they're not going to have both the litigation privilege and the business judgment rule. Nothing requires them to just choose between the two. Lastly, as Justice Francis French noted, the idea is to end litigation, not to promote it. I have one last point before I hand off the baton to Scott Ratchick, and of course I'm here to answer your questions. Looking again at the receiver's complaint, page 8, paragraph 27, page 11, paragraph 42, page 12, 47, he says something very specific each time. He says that the CSSA members, Chip and Ed, were acting in the interest of their member companies. As a matter of law, he has just failed to state a claim. The reason is we're governed by Delaware law. And Delaware law says their duty was to the member companies.
Well, if that's the case, why wouldn't we just remand it to the Court of Appeals to apply the business judgment rule? And if you're correct, their conduct would be immunized under the business judgment rule.
Well, that's certainly one possibility, Justice DeWine. The other possibility, and again, I don't think you even get to the business judgment rule, because if we accept the proposition that they were answering a question from the court as parties, and the CSSA was a party, and they say we want to hear the jury rule, then that would render them completely immunized. But if we go back down, certainly if you get to right now, the court could look at it and say, when we look at the complaint, he fails to state a claim. Therefore, I think the trial court and the appellate court got it correct. May I transfer matter off to Scott Ratchick, please.
Good morning, Madam Chief Justice, Justices of the Court, may it please the Court. My name is Scott Ratchick, and I am co-counsel for appellee Edward Slish. Justice DeWine, let me take up your question. Under your hypothetical, I would argue two things. One, if the decisions were made outside of the context of a proceeding, meaning before a litigation was filed, there's case law that suggests those actions are not protected by the privilege, including, for example, Wolitzer, which suggests that activities undertaken before a litigation is filed are not protected. The same is true in the Page Capital case. If the actions that you described were taken in the course and scope of and were reasonably related to the active litigation or judicial proceeding, I would argue, Your Honor, that yes, the privilege does apply.
So if directors are blatantly self-dealing, if they reject a settlement offer because they want their brother-in-law's law firm to make more money, there's no fiduciary claim that can be asserted against them.
Your Honor, and I will answer that question and then bring us back to these facts. But under the circumstances that you just raised, there are other alternatives for recovery from by that corporation. They can go after the brothers. They can fire the director. They can, whether or not there are other sanctions that might be available, the answer is they can pursue those.
But they can't go after the director for breaching his fiduciary obligation to the company.
In the context of the litigation privilege, that would be correct, Your Honor. But we don't have those facts here. And to reiterate what Mr. Pollack said, we are dealing with these facts here. The rule may not be a perfect rule, but this court has acknowledged that it's not a perfect rule. And in both Wolitzer and under Suris in particular, this court has made it very, very clear that conduct which otherwise would be actionable is to escape liability because the defendant is acting in furtherance of some important social interest. And additionally, that although the result may be harsh in some instances and a party to a lawsuit may possibly be harmed without legal recourse, on balance, a liberal rule of absolute immunity is the better policy as it prevents endless lawsuits. Those are the words of this court. So, Justice DeWine, while you posture a hypothetical to us that is on the extreme edges, I would say that that falls squarely within the precedent of this court, recognizing that that injustice may occur in limited situations, just as the appellants suggest that a ruling in their favor or a ruling in our favor is going to create assault and battery in the courtroom and witness tampering and all of those things.
Couldn't we accomplish the same thing by putting this in the context of the business judgment rule, explaining that, well, maybe there's no litigation privilege. The business judgment rule provides broad protections for good faith decisions about whether to continue litigation?
You could, Your Honor, but that's not what the litigation privilege is intended to do. It is intended, as Justice French alluded to earlier, to end follow-on lawsuits and to allow participants in a judicial proceeding to act and to speak as zealously as they can, so that, and they can do so without fear of follow-on lawsuits.
But this isn't really about speaking zealously, right? It's about the problem I have here is we're not talking about speaking zealously in litigation. We're talking about decision making that would ordinarily seem like fiduciary decisions.
Your Honor,
there's nothing to do with speech in litigation.
Well, the decisions here were actually spoken. One, the decision.
Almost all decisions are going to be spoken. I mean, that seems.
Yes, but how much more communication can we have than in this case where they're accused? And I understand my time is running up. If I might finish your question. The decision here was that they're being accused of is opposing a motion to dismiss. And that communication, that decision, and that argument to the court is what is centrally at issue here. As Mr. Pollack alluded to, that's what the cause of action is here. So I would argue to you, where more can you get either one, a communication, two, as Justice French alluded to earlier, seeking the truth. How much more truth-oriented can you get than we want the jury to decide? And so, Justice DeWine, while I understand you're looking for a broad rule, I'm not sure that this is the case that can give you the opportunity for a broad rule. But what this case does afford you is an opportunity to properly apply the litigation privilege to the facts of this case, where the directors, instead of doing any of the parade of horribles that are noted, simply said to the court, we want the court to decide. They had an independent judge with the ability to regulate that courtroom.
Thank you, counsel. Counsel, thank you.
Okay.
You've used your time.
Thank you, Your Honor.
All right, Mr. Helmer, you have, looks like 1 minute and 47 seconds.
Thank you, Your Honor. Justice DeWine, you were told that we failed to state a claim in this case and that remanding this case could solve the problem. The problem with that, Your Honor, is the trial court was specifically asked to rule on that issue and did rule on that issue and did determine the receiver stated a cause of action. That was not appealed by either of these directors, although they did appeal other issues. They didn't appeal that issue. Justice French, as to ending litigation, after listening to Mr. Ratchek, I'm sure you're now convinced that with all these other remedies that corporate directors would have, that he claims they would have, litigation wouldn't be in it at all. It just would be moved to a different courtroom. Next, Your Honor, you were told that this settlement offer was accepted by Certified Steel. And if you look in the brief, you're going to see the only citation to that is our complaint at paragraph 17. We do not say that because that's not true. Finally, this decision was like the Procter & Gamble hypothetical, was made in the boardroom. It was made the night before in the boardroom to turn down this golden ticket settlement. And as a result, Certified Steel got hit with a $43 million jury verdict that it cannot pay. It's the trial judge that handled this case did supervise it, and he's the one that not only warned counsel of their potential breach of fiduciary duty, he appointed John Reister as a receiver to look into that issue, investigate it, and litigate it. We ask that you reverse the decision of the Court of Appeals.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.